Yeah, you said it's incomplete arraignment.
Yeah.
What's that mean?
Well, you didn't take any time this month to kind of go to the library and research court cases so you know what you're talking. I assume you want to represent yourself, or do you want me to have P.D. Bergeron introduce himself and you go in the room and talk this thing out?
I'm just a private American here. That's it. I don't need to represent myself.
Everybody else in this room is a private American.
Well, I don't need to represent myself. I am an improper person.
But you've been charged with violating certain
So
laws.
I'm just saying, what did you mean by the incomplete arraignment?
You didn't get all the paperwork so that you could study what you need to prepare for.
What paperwork?
Copies of the charges.
So I did receive copies of the charges from the DA after the first arraignment. That was the first time I ever received anything.
Did you receive this whole packet from the DA's office?
Yes. On January, it was dated January 29th. This is what I received.
It was part of the 7/10/30 notice, Judge.
Oh, that's the 7/10/30.
This is what I received after the first arraignment.
Well, as I told you, that was an incomplete arraignment.
And I'm asking, what does that mean? I don't know what that means.
You do not have here in this file what I have to give you from the court. These are the charges. These are not the charges. These are information from the DA's office. These are the actual charges that you have to work upon. If you want to go to the library or go on and try to defend yourself.
Okay.
I'm assuming you want to go to trial and defend yourself. Is that my
Well,
correct picture?
I'm still here by special appearance, challenging jurisdiction. You said in your letter that dismissal is not an option. I still reserve that right for dismissal based on constitutional violations. I have not given this to you, but you will have a copy of the original sent to the clerk. This is a copy of the original, the writ, the order to dismiss, which I don't feel has been given a good faith effort to review,
Yes,
point
I
by
have,
point.
sir. Do not discount what I do at
Entry.
my court.
Well, you mentioned a phone call. That's completely disregarding the paperwork that I filed. So this is the entry of evidence,
I did.
including.
I made a phone call to you, sir.
No, I made a phone call to the clerk, and that's what you referenced in the letter. You did not reference my motion that I filed with the court.
Because we don't have a proper start to this whole thing, because we have an incomplete arraignment. That's what I'm trying to accomplish.
So I have provided.
So you have the information that you need to proceed with this situation.
Okay. So,
The court is not impeding you. The court is trying to help you.
in the interest of justice, the court would move for dismissal.
I will not
With prejudice.
dismiss these charges. We
And
will either
you're not gonna.
negotiate this or we'll go to trial, one or the other.
What do you mean negotiate?
P.D. Bergeron can represent you, or if you want your own lawyer from Albany to represent you.
So, I remember during the first arraignment, the incomplete arraignment, you had asked me if I was a sovereign citizen, and I wasn't too familiar with that, so I did a little homework on it. And I just want to say I don't subscribe to any political ideology in that manner. However, I did come across the House Joint Resolution for I Am American Citizen Day. And in the preamble, it says, whereas it is desirable that the sovereign citizens of our nation be prepared for the responsibilities and impressed with the significance of their status in our self-governing republic. And so I wasn't sure.
Which paragraph are you referring to?
This is the preamble, the second paragraph. This was signed in 1940. And I wasn't sure if your question was meant to be derogatory, if it was meant to be complimentary, but
It was meant to give me a handle on where you wanted to go with the case.
Okay.
That's all there was to it.
Well, the fact of the
The
matter
court
is,
system is not derogatory to defendants. Let's make that perfectly clear right now.
okay. Well, I said I wasn't sure how to interpret it because I've seen in the past it being used in derogatory ways. I'm not trying to assume anything about you, sir. What
No,
I'm
the court system, I represent the court system. And I have to come
Okay.
in here and I have to leave whatever biases or whatever I may feel, they're out in the driver's seat of my old car,
I respect that,
okay?
and in the interest of a good faith effort to review my motion to dismiss, I'm just gonna go over it.
Well, sir, what I'd like to do tonight is finish the arraignment, give you your copies, and we'll have another adjournment, and you figure out in another month's time where you want to go with this, whether you want to employ an attorney of your own, or whether you want PD Bergeron to represent you in this case.
I'm very clear where I'm going with this. This is definitely abusive practices that were employed by these law enforcement officers, and it is legally preventing prosecution. It's a legal impediment to prosecution, and so if this court can't recognize it, I have to seek another court too. Now I'd like to make one more good faith effort to go over the motion to dismiss that I have filed with the
Well, if you
court.
want, let's go back to my original thing. We have to complete the arraignment. We're going to accept these copies of the charges that were lodged against you. Are you going to accept these?
I don't understand those charges, sir.
But if you don't accept them and you're not able to read them and research them, we're at a quandary. We're in the middle of
Why
a mudslide.
why do you feel as though I need to receive that from you as opposed to the district attorney's mailing?
Because the district attorney's mailing doesn't have all of this in it.
Which is what?
The charges of the offenses.
Yeah, I got the charges from the law enforcement officers.
And what we do in the system, in case those get lost or damaged, we give you clean copies at the arraignment.
Okay, I appreciate that.
And your attorney.
I appreciate that. I have the tickets.
So you're not gonna accept these again.
I don't understand those charges.
And that's why we give them to you so that you can study.
I will never understand those charges.
Well, perhaps your attorney or PD Bergeron can help you through it.
Well, before there's any way we can move forward, there has to be some evidentiary hearings. And I'm still challenging jurisdiction in those hearings.
When would you like to have an evidentiary hearing?
I mean, we can do it right now.
I can't.
Okay.
I could do it sometime during this week, during the
Okay.
day. I would adjust my work schedule and come in.
All right. It would be under protest just because I feel like things should be dismissed as of now.
PD Golden, do you have any words of wisdom?
I don't know that I have words of wisdom, Judge. I would just like the court, if you would, to identify what the charges are and to ask Mr. Wilson whether he has received that charge.
I got the mailing that I showed the court that you sent on January 29th.
But I understand you also said you got copies from law enforcement.
Correct.
So I
At
just-
the site.
At the site.
Correct.
And
Sorry.
you retain those. They're not damaged.
Correct.
The print is still you can read it and everything else.
Correct.
So Judge, I would just suggest that we identify ticket number or charge number 1 and ask whether or not he had received that copy.
All right, then, Mr. Wilson. Ticket number S241230258, charging you with 1192.4 DWAI by drugs. prior conviction designated offense within 10 years. That's the first. The other ticket is S241230-260, charged with 1120A, failure to keep right on a 2-lane road.
Judge, I would ask if he has received those, or maybe you want to ask it all together, but I would ask for a response after each ticket.
Okay, well, here again, I'll go back to the first one, S241-230-258, 1192-4, DWAI by drugs, prior conviction designated offense within 10 years. Have you received that ticket?
I received and I denied.
Okay, and then the next one.
S241-230-260, 1120A, failure to keep right on a 2-lane road.
I receive and I deny. I receive and I deny.
S241-230-262, violating 1128B, illegally driving in the center lane.
I receive and I deny.
S241-230-259, violating 1227-1, drinking alcohol or using cannabis in a motor vehicle on a highway.
I receive and I deny.
S241-230-261, charged with 1128A, moved from a lane unsafely.
I receive and I deny.
S241-230-263, 1128C, failed to use the designated lane.
I receive and I deny.
And you understand that the 1192-4, because of your prior conviction, is a felony count. And also, we have a refusal to submit to a chemical test. Did you get that copy too in your file?
I receive and I deny.
You understand that the reason I'm trying to complete this arraignment is I have to take your license now because it's a refusal.
Okay.
Right.
I don't consent.
I beg your pardon?
I don't consent and I don't stipulate.
But you've been charged with refusing a chemical test, so I'm having to take your license. You will lose your license tonight.
I hear you, sir.
So can I have your license and file it in my file? And then
I don't drive.
DMV will be calling you by phone to hear you on that charge.
I don't drive.
How did you get here tonight?
That doesn't matter.
It certainly does. If you don't have a license, how did you get here? Did a friend bring you? Did you take a bus?
I travel.
You what?
I travel. I travel.
You travel.
Yeah.
With commercial carrier or?
No, not for hire, not commercial.
I'm still cloudy as to how you're getting around legally without a driver's license.
I travel lawfully, sir.
With a New York State driver's license,
No,
a California license, a Massachusetts license,
I am not licensed, sir.
then you can't travel legally around here unless you're hitchhiking, riding a bicycle, or you get a taxi.
Okay, well, the Supreme Court disagrees.
Not the last time I heard. 88
Okay.
Golden, did you hear that one?
No, Your Honor, if I could just, I think, as I understand it now, Mr. Wilson has already received all of the accusatory instruments in this case, all of the charges. I understand by his colloquy that I deny, or I
Receive but deny.
deny. I would consider that to be entry of a plea of not guilty to these charges. I think for purposes of arraignment, that's all we need to do. The administrative part of having him surrender his license would not apply in this case because he states he has no license. So
All right.
I think for purposes of this proceeding, the arraignment has been completed. With the entry of a plea of not guilty then on each of the charges that you identified.
I don't consent or stipulate a plea.
I'm sorry, sir.
I don't consent or stipulate to a plea.
As the courts have recognized, even standing silent or not recognizing the entry of a plea is in effect a plea of not guilty.
I just want to object and be clear that I reserve all my rights.
Okay.
All right. So you are requesting an evidentiary hearing?
Correct. The Huntley and Rodriguez hearing.
I beg?
Huntley and Rodriguez hearings?
So you have been studying this. I asked you previously if you had time to study this all over, and now you're coming up with legal terms. So
I shepherdized all the cases
I
that
beg your pardon?
I shepherdized all the cases that I listed.
I'm sorry, you,
I shepherdized all the cases that I listed.
I see.
Judge, if I may, I haven't seen these papers, or I haven't, they were handed to me tonight. I haven't had an opportunity to read what's in them, but I do understand that these are all written requests to have the charges dismissed,
And exhibits A through E.
and exhibits A through E. So I would
The court
treat,
has not received those.
Yes, the court has. I have a green card returns receipt showing you them.
Oh, you mean these? Okay, the big long form. Yes. No, I went through those, but
Okay.
that's not what we normally get here, sir.
I understand. I just request that you please look through it and substantially respond.
And that's when I wrote your letter saying that you should come back to court and complete the arraignment. So now the arraignment has been completed. You say you don't want these forms, so we will just keep them in your file.
There's nothing written from you directly concerning the files. Nothing.
Yes, there is, sir.
Nothing.
I wrote you because you would not complete the arraignment last month.
What's
Now
it-
we have completed that.
What does that have to do with my
was that later.
filings?
I beg your
What does
pardon?
that do with my filings?
That has to do with the progress of a case.
Okay.
This small court sets the order of the case.
Okay.
That's our job.
I hear you.
So now this first segment of this has been completed. Now we have the arraignment completed. You are charging a evidentiary hearing. Is that what I'm hearing from you?
I'm demanding it's required.
88 Golden, what is your docket like?
no, I think, Judge, I have received these papers tonight for the first time, which I have not reviewed, obviously, in this short period of time. But if we were going to treat this as a written motion to dismiss, or perhaps an omnibus motion, that we would adjourn the case for, let's say, 60 days to give us an opportunity to respond and provide the court with what our response would be to what I understand to be written motions to dismiss.
Correct. And just to be clear, this is just for Claverack Town Court. I also submitted to the court the paperwork for Livingston Town Court because the incident is separated into two courts. So if you would like the Livingston Town Court paperwork, I can give that to you as well. It's just Claverack because you're here.
And what charges are from Livingston?
It's minor violations. What I learned in my experience driving through Claverack is that law enforcement makes a habit of trying to do a DUI bust, and they unlawfully arrested me and searched and seized my property. Period.
Golden, you're saying 60 days.
For a response.
So we'll make it April 18th?
18th or 15th, Judge?
Well, that's my court night, but I mean, as far as
Oh,
IAM.
18th, yeah, the 18th would be 60 days, right?
All right. And I'm sure ADA Gold, if you prefer the 15th, I'll do that. I'm just,
No, I think that's fine. That would be just for our response. The question is, when would you like Mr. Wilson to be back here in front of you? The 60 days would be just for a response, which is what we would normally get. If you want some additional date for response, perhaps the May date, to give him an opportunity to respond.
Yes, we look at the calendar. Your date in May will be May 13th.
so that will be the control date. All right, sir. You're gonna get a response by 4/18, and then you're gonna have a control date on May 13th. Right?
That's all.
That's it.
Have a good night, guys.